Welcome to the final of 3 meetings of the Unemployment Insurance Study Committee. Today is November 18th, 2021. We are in a particularly echoey room today, so apologies to anyone who is watching us and struggling to hear. We have a wide-ranging agenda to try to move closer to some decision points on the work that we've been going through, but are not going to be finalizing our draft report today. We're going to be finalizing recommendations towards that report today. I think that's probably the clearest way to say that. And so we're gonna finish our conversation about penalty weeks, finish our conversation about reimbursable employee changes, and then talk about the trust fund and the report. Yeah, so all that, and then just sort of the ongoing theme that we've been talking about through this entire process, I think, is that some of the work we're doing will be implemented in this glorious future when the Department of Labor has a new computer system. And some of the things that we're talking about could be implemented sooner. And so we're always conscious of how that shapes our choices and our deep desire to not crash the unemployment insurance system. Because the most important thing is that Vermonters get their benefits. Damien, can you talk to us about penalty weeks and some changes that we have been considering on penalty weeks legislation? Thank you.
For the record, Damien Leonard, Legislative Counsel. Would you like me to start with the language for the waiver of federal overpayments before I go to the penalty weeks, or do you want to start?
Yes, that would be great. No, overpayment sounds great. And the last thing that I want to sort of throw into the mix actually before you start that I forgot to say is that sort of intrinsic to all of these conversations around penalty weeks and overpayment and all that stuff is definitions of fraud. And we are still waiting on the the auditor's consultant's report, which goes much deeper into how we might better organize our fraud definitions. And so some of that will be left a little bit blank pending that report. Back to you, Damien.
All right. I'm going to pull some draft language up on the screen for the committee here. Everyone can see it now. So the first language I'm showing you is language that we would need to enact if we want to provide authority for our Department of Labor to waive overpayments of federal benefits from the pandemic. There are specific requirements that were outlined by the Federal Department of Labor in a recent unemployment insurance program letter, and this is designed to mirror them. I have not run this language by the department yet, so there may be some minor edits that need to be made after they've reviewed it. So the first paragraph here provides that the Commissioner of Labor, consistent with applicable federal requirements, may waive some or all of an individual's liability to repay and overpayments of benefits provided through the Pandemic Unemployment Assistance, Federal Pandemic Unemployment Compensation, Mixed Earners Unemployment Compensation, and Pandemic Emergency Unemployment Compensation programs. If the Commissioner determines that both the individual was without fault and requiring the individual to repay the amount of the overpayment would be contrary to equity and good conscience. The and is a requirement for the federal waiver. And then I've added in language in subsection B, adopting the federal definition of contrary to equity and good conscience. We could adopt our own state definition, but in the absence of a state definition, the federal definition would apply. So I've added this language in since we don't have a state definition currently, just for clarity's sake. But this is something that could be adjusted. So the contrary to equity and good conscience would mean that it would cause financial hardship to the individual, be unconscionable, or that the individual can demonstrate that they have relinquished a valuable right or changed positions for the worse because of the incorrect payment or notice that the payment would be made. And this is a determination that would be made by the department. Any questions?
I have a question. So I appreciate that the federal government defined equity and good conscience. I'm confused that unconscionable is, what is, I mean, that seems just as vague as equity and good conscience to me. Do you have any sense of what that word could mean? So hard.
Sure. I'm just going to pull up the definition of it.
And like Webster's, is that what we're going to do?
That's exactly what we're going to do. So it means not right or reasonable. So shockingly unfair or unjust, excessive, unreasonable, not guided or controlled by conscience. And this is from Merriam-Webster online.
Okay.
So I think shockingly unfair or unjust is probably a good expression.
Well, just on a related note, how could, I'm struggling, and maybe we should just not worry about it, because this is taken straight out of federal language, is that what you're saying?
This is straight from the federal guidance. I reworded it slightly just to make it flow better and fit our drafting style, but other than that, it's the all of the essential elements are identical to the federal.
I'm struggling to think of something that would not cause financial hardship, but be unconscionable. That's, I mean, if you're paying back money and it's a problem, I just, anyway, it's a silly exercise perhaps, but.
Right, I think the point here is that it allows the commissioner to consider various factors where there may be some overlap, but there may be instances where the facts maybe indicate that it wouldn't cause financial hardship, but requiring repayment at this point would be extraordinarily unjust under the circumstances. And I can't think of,
Maybe it was 2 years ago.
Yeah, I think it's
Okay.
right, so I can't think of the specific facts, but one thing I've learned over the years is someone can always come up with a fact pattern that I haven't been able to come up with or consider. So yeah, I think the possibility is out there, and this provides that breadth. Again, I haven't run this language by the department, so they may have guidance, and also we're joined by Kelly Kazmarski from Legal Aid today. She may also have some thoughts on this language, having more experience dealing with unemployment claims and so forth.
This section particularly is specifically this language though, because it's specific to the federal PUA.
Right, and
It's for the federal PUA.
yes, and it's worth noting that the federal guidance on this says if the state has its own standard, it can use that standard for contrary to equity and good conscience. However, if it doesn't, the federal standard applies. So I put the federal standard in here because we do not have our own standard. I don't know how the federal department would treat the state adopting a standard midstream at this point. So, and that is something that if we did want to adopt another standard, we'd want to make sure that there's not a federal conformance issue if we were to do that, particularly if we adopt something that is less restrictive than this.
So you're saying this isn't actually a change from the current landscape, it's just clarifying?
Yeah, well, the change from the current landscape is that we're providing express authority in our statutes to do it. And this is different than the language we've created for the waiver of an overpayment for regular UI payments. So this is a necessary clarification because our waiver language is more liberal than the federal requirements and doesn't meet the federal standard for waiver of the federal payments. So we could not apply the regular UI waiver language that this committee has been considering to federal overpayments. So this would go in as a clarification in any bill that adjusted that waiver or provided that waiver authority to the department.
Thank you.
Senator Strachan?
Thank you. Damian, have you spoken with the department on any computer problems to have two different standards for waivers of overpayments?
I have not, so that's something that we would likely need them to speak to, and I think they're scheduled shortly after me on the agenda this morning.
They are indeed.
Thank you.
Any other questions on this little section? Okay.
Great.
Does this work for everyone?
I think so far.
Okay.
Okay, the next thing I'm going to pull up is, this is a modification to the penalty weeks and overpayments draft language we looked at a month ago. And I will scroll, the language is unchanged except where I've highlighted it. So the first additions are in the provision that provides for the assessment of a penalty for fraud. And this would require the department to find by clear and convincing evidence that the individual committed fraud. So it's a clarification to the existing language that does not set a standard as to the finding of fraud. And then this is something that the department and Vermont Legal Aid can both speak to as to whether it's appropriate and why or why not we might want to include this language. The next would be change.
Could I just ask the 3-year window? What happens if we're outside of that? Is there a default sort of?
Are you talking about the window that we're creating for?
Page 3 here, line 8 says that the determination shall be made within 3 years. Or within 1 year from the date of the room. So that's a determination of
That's a
sort of thing, or what?
no, that's a statute of limitations on making a determination that an overpayment occurred.
And so if it's 3 years and a day, it's just, we're done with this and you cannot make that determination.
Right, once we pass 3 years, the department doesn't have the authority under statute to make that determination anymore. So as a practical matter, I think the determinations are made much quicker than that, but Cameron can speak to that since this is more in his area of expertise. Other questions? The next is in subsection D. This is language intended to address some of the issues, again, from early in the pandemic where individuals had an outstanding overpayment and had become unemployed. And what this would do is limit the withholding of future benefits to repay an overpayment to not more than 50% of the benefits payable. Senator Strachan, did you have a question?
No, I was just coughing. Sorry.
Senator Strachan, do you mind muting yourself while
While I cough?
Yes, thank you so much.
So the current language provides that the department can withhold in whole or in part any future weekly benefits. So this would be limiting them to not more than 50%. And the department can speak more to current practices and how they work within this language during the pandemic. and what this change would mean for them. And it's worth noting, I have not talked to the department at all about whether this would cause a mainframe issue. I don't know the extent to which this calculation is done within the mainframe, and how difficult it would be to change that if it is. And then the final change proposed here is, again, this is with penalty weeks. So again, it's adding the by clear and convincing evidence requirement for a finding of fraud before penalty weeks can be imposed. And again, this is something that Vermont Legal Aid and the department can speak to more as to how this would change the current playing field and the extent to which this is either desirable or not. Are there other questions on this language? Oh, there is actually additional changes. I'm sorry. So the next changes here are in the reconsideration language that we're proposing to add, allowing for someone to file for reconsideration within 2 years after a determination of fraud. And what this allows here is the original language said that this wouldn't affect any penalties or penalties paid or penalty weeks served prior to the determination on reconsideration. And the language in yellow here would allow the commissioner, if the commissioner modifies or overturns the original determination, it gives the commissioner discretion as appropriate to retroactively restore benefits to an individual for weeks in which the individual was improperly disqualified from receiving benefits or had benefits improperly withheld. And
can I try this one in regular language?
yes.
Thanks. So someone has a finding for fraud, appeals it, they're found to not be having committed fraud, and so any penalty weeks that they served under the previous determination of fraud are paid back to them if the commissioner so chooses.
Right, and the one important correction I would make is this is not an appeal, it's a motion for reconsideration after the time for appeal has
Thank you.
expired. So it's, and this whole section is based on testimony that the legislature received early in the pandemic of individuals who did not appeal the finding for a variety of reasons at the time, only to later realize when they needed the benefits that they were disqualified, whether it was a lack of understanding or a lack of understanding of what rights they were waiving at the time. They were then disqualified from benefits and had no recourse at that point. So this would allow them within the 2-year window before the period of disqualification expires under the proposed language to file for reconsideration. And then this language allows the commissioner, if the commissioner determines it's appropriate after modifying or overturning that original determination, to retroactively restore benefits. I would note that my cross-references here are reversed, but just for anyone who's
I
reading
caught that, I just
closely,
didn't want to embarrass you.
anyone who's reading closely, I've noticed that, so please don't email me.
There were a number of people during the pandemic that were serving penalty weeks and weren't able to get their unemployment benefits. So would this, could they come back now for redetermination if they're found to, the commissioner finds that they shouldn't have been serving penalty weeks? Could they get their UI that they should have gotten during the pandemic?
No, so the language I just pulled up on the screen here on lines 8 and 9 would say that the reconsideration shall not affect penalty weeks served or penalty amounts paid prior to the effective date of this act. So it would be prospective. And then the the aim here is to fix the situation going forward, not to require the department to reopen a large number of claims from the pandemic and try to retroactively provide benefits.
One issue that I was wondering about would be the $600 extra payment a week that the federal government was providing. They would have been eligible for at the same time. I'm afraid that we might be on the hook for that too. So thank you.
Yep. Yeah, so the idea is that this would be a prospective change, not a retroactive change.
And I think it's that I mean, at least I heard from a number of constituents who, it became clear to me how much in sort of the chaos of losing a job and filing paperwork, one sort of loses track of details when there's tight turnaround times. Yeah. My coat driving you crazy? Okay, because I can just shut up.
No problem.
Okay,
Great.
so that's it for the language.
Thank you.
Do you see a question?
Senator Strachan, did you have a question?
Oh,
You need
you're
to unmute
muted,
yourself.
Senator.
I'm having a little difficulty hearing, but has this section been changed since the last draft? Because there was a provision that I had concerned about that any reconsideration shall not affect penalty weeks served or penalty amounts paid prior to the date of the commissioner's decision upon reconsideration.
Yes, this is a change from that draft that had that language in it. So this allows prospectively going forward, the commissioner could retroactively make adjustments for benefits that the commissioner determines the individual was entitled to but did not receive after their reconsideration. So this would it would mean that individuals wouldn't miss out on benefits that they should have been entitled to if the commissioner determines that there was a mistake made in the original determination.
And the prospective nature of this section relates to the date of the act now?
Right, so if this language is enacted, I've set that date at the effective date of the act, so it'll just be going forward from when the change takes effect in law, so that the department wouldn't have to retroactively process claims from the past and try to figure out how this language applies to claims that it has handled in the past couple of years. So this would just be something going forward, particularly since going forward, the department would also, if this all passed as a package, the department would also be dealing with expiration of penalty weeks after a few years and other waiver provisions going forward. And so this would just be part of that package going forward.
And current law is that there is no right to reconsideration. So we're
not for this determination. There is a right to reconsideration on a benefits determination. So if you've been denied benefits, you have, I believe it's up to a year to file for reconsideration. And same thing if I believe it's any benefits determination, whether it's a claim that's granted or a claim that's denied, there's a year to file for reconsideration. And then that could move forward, but this is currently we don't have a reconsideration specifically addresses a finding of fraud. There is an appeal period, but no specific provision for reconsideration.
okay. Thank you.
Damien, would the reconsideration by the commissioner, the plaintiff filed that, is that final? The determination that the commissioner makes, is that a final determination? Yes or no? There's no other appeal or to the Supreme Court or anything else?
The way it's worded now, there is an appeal right, the same as for the regular reconsideration. So it's an appealable decision. So that's another policy issue the committee or the committees of jurisdiction during the session may want to consider, is whether you want to make this a final decision at that point, or limit the options for appeal or anything like that. So, yep.
Everyone ready for, great, okay. I think now we're gonna go over to Kelly.
Excuse me, Madam Chair.
Yep.
I have one more question for Damien, and I missed it early on. I think it's on the second page. The version that we had been working with before made waiver of an overpayment amount mandatory under those circumstances. Two questions. One, was the version we had before applying to the regular UI program, and now this section only applies to the federal benefits?
No,
Section.
so there are two different sets of language. The first language that I went through, which is on today's handout, page 1, deals with the federal benefits programs. On page 3 of today's handout, or starting on page 2 of today's handout, we're dealing with regular UI. And the language you're talking about is subsection C, which begins on line 11 of today's handout. And it still provides a mandatory waiver by the commissioner if the overpayment or if the individual is without fault for the overpayment, and then allows a discretionary reduction or waiver of the amount if requiring repayment would be contrary to equity and good conscience. So two different pieces there, and this is just for regular UI benefits.
Okay.
This language would not comply with requirements for waiver or reduction of an overpayment of federal benefits paid during the pandemic.
Okay. So on the regular benefits, we dealt with this in our committee somewhat. I don't know if it's last year or the year before. And Senator Brock was quite concerned, and I share some of his concerns, that just what the definition of without fault is. I mean, I support this section to waive situations where people are not at fault, but the question that was raised in our committee was, what if a beneficiary got, a $10,000 check in the mail that he or she clearly knew was a mistake? He or she was not at fault in causing the issue of that overpayment or that benefit check, but is there no power within the department to try and get that money back?
Senator Sorokin, at the beginning when I mentioned that some of the fine details of this might need to wait for the auditor's report, that was exactly the kind of scenario that I was thinking about, because I think we don't have as clear a sense of the scale and range of what we're talking about when we define fault and not fault as we could be operating under. And I didn't want us to wait for this whole conversation until we had that report. But I do think that that's like exactly the detail that we could plug in once we have the report, because that's something that I know they're diving deep on.
That's fine. Thank you.
Any other questions? Okay. May I be excused,
You
ma'am?
may.
Okay,
Thanks,
thank you.
Julian. Good morning, Ms. Kozmarski. Thanks for joining us.
Thank you for inviting me. Good morning.
You can introduce yourself for the record and share your thoughts on this section, please.
absolutely. For the record, I'm Kelly Kazmarski, staff attorney in the Poverty Law Project at Vermont Legal Aid. Good morning, and again, thank you for inviting me to comment. I have not actually, I'm just reviewing the language that Damien just reviewed right now. So I'm just learning about these changes. And I guess I'd like to start by saying that legal aid definitely supports the change of elevating the standard of proof for a finding of fraud to clear and convincing evidence. This is not, of course, the standard for criminal prosecution, which would be beyond a reasonable doubt, but a finding of fraud within the context of our statutory scheme still results in prosecution. It could result in additional prosecution, even if it is a sort of civil quasi-criminal prosecution. And in other contexts, findings of fraud generally need to be supported by clear and convincing evidence. We furthermore had many experiences during the pandemic of folks who came to us with these findings of fraud on their record and the imposition of penalty weeks with really what seemed like a lack of evidence supporting that finding of fraud. In many instances, clients reported to us that they never spoke to anyone from the Department of Labor before that finding of fraud was made. And so we had strenuously objected to the enforcement of those old penalty week determinations during the pandemic because so many clients were telling us about what appeared to be a rather unsupported finding of fraud after an investigation, which sometimes did not even include a discussion with them. And finding this, requiring an elevated standard of proof would at least address these sort of questionable findings of fraud and would in turn make enforcement of any penalty weeks that a claimant has to wind up serving, it would make it less problematic if there was a finding of fraud supported by clear and convincing evidence. Having said that, we also, on the issue of penalty weeks, legal aid supports very much the change that the penalty weeks would sort of disappear after a period of time or during another period of crisis like we just experienced. We think that that would be a huge improvement if we ever have to face an economic shutdown again in the future like we did, because families really were left in a horrible situation with these penalty week determinations hanging over them when the pandemic began. Many of our clients actually had tried or endeavored to pay back overpayments, sometimes years before the pandemic began. And we had many clients who had already paid back the overpayment, had not been unemployed, sometimes for many years. And then the pandemic hit. And when they went to apply for benefits, only then discovered that they were out of luck. And so we had clients who were not only terrified about how they were going to support their households and pay their bills, but they also were very angry about the fact that between the penalties, the 15% penalty imposed, the overpayment that they've already paid back, and now this loss of income, which they would have been eligible for, which again, during the pandemic with the additional supplements, meant for many clients, they wound up paying back their overpayment several times over and experiencing this horrible stress of not being able to support their families. So we're glad to see these changes in the penalty week statutes, and the ability to seek a waiver of an overpayment is something else that is definitely an improvement for the state and the federal benefits. And the ability to seek redetermination of that fraud finding is an excellent improvement. I would suggest on the definition of, well, I guess I'm now sort of going back to the overpayment issue and the waiver of benefits. I'm sorry, the waiver of an overpayment. I guess there's a few issues I want to talk about that are going through my head at the same time. First, I guess let me first address limiting the recovery of an overpayment to 50%. There is precedent for this in other states. I just wanted to let you know that I've done a little bit of research, and it looks like at this point I found at least Minnesota, Pennsylvania, Virginia. It looks like there are others as well, Arizona and Ohio. Also in their statutes provide that the Department of Labor may withhold in some cases up to 50% of current or future benefits for recovery of an overpayment. In some cases even less. One state authorizes in Arizona 25% of current benefits may be withheld in non-fault overpayments. And then in another state, the standard was that the department could withhold up to a third. But there's good cause. It makes logical sense to not withhold the entire amount. If a person is eligible for unemployment benefits, by definition, they have lost their income through no fault of their own, and it's often on short notice. And the purpose of the unemployment benefits to begin with was to help families maintain their households and not have to go on other forms of assistance during times of temporary, unavoidable loss of employment. Those circumstances don't change just because a person has an overpayment that needs to be paid back. And so while it does make sense, you know, that obviously the state does need to recover overpayments for which the claimant has not been found without fault. But families still need some sort of income, and the household still needs to pay its bills during that period of unemployment. So we would strongly advocate for the limit on the amount of withholding the department may impose to recover an overpayment. And then on the waiver issue, earlier you were speaking about the definition of equity and good conscience. I guess there's two things on that point. In terms of the federal definition, I also work on Social Security cases at Legal Aid, and the definition for waiver of an overpayment in the Social Security context or the factors necessary are the same as Damien reviewed. And that federal definition of equity, if the repayment of the overpayment violates equity and good conscience, it proves to be very cumbersome in the Social Security context. In my research, I discovered for the state of Virginia has its own standard for what it means to go against equity and good conscience. And I understand what Damien was just saying, that the federal standard applies in the absence of a state standard, and there's some question about whether changing that state standard now would do anything to the recovery of federal overpayments. But let me just read to you that in Virginia, the definition of contrary to equity and good conscience means that if requiring repayment of an overpayment would deprive the individual of the income required to provide for basic necessities, including shelter, food, medicine, childcare, or any other essential living expenses. That seems like a pretty plain language standard to use for violating equity and good conscience. So that might be something that The
Can you-
legislature,
Can you
Sorry?
read that one more time? Can you read that one more time?
certainly. Contrary to equity and good conscience, let's see, it would be contrary to equity and good conscience if requiring repayment of an overpayment would deprive an individual of the income required to provide for basic necessities, including shelter, food, medicine, childcare, or any other essential living expenses. And this is from the Virginia statutes. I can get you a cite. They also, interestingly, allow in a situation where an overpayment is not forgiven or waived, the department can collect by withholding up to 50% only of current or future benefits, or foregoing collection until the recipient has found employment. That's kind of an interesting option, I think, too. They can institute an individualized repayment plan with the claimant. So there's the 3 different methods that the department can collect any overpayment that's not waived. So, pardon me, the reason I didn't come today is because I do have this scratchy throat. So I guess that really concludes my comments. Legal Aid definitely supports the amendments that you all are considering, and I would be happy to answer any questions.
Thank you. I'm excited that you support this. I would be curious to see that other language that you just read aloud, because I really just don't process information very well that way. And question? No. Senator Pearson, any questions?
No,
Senator Trotkin.
Thank you very much, Kelly. Do you have any cause for concern that on the retroactive limitation on overpayments or penalty weeks, I can't remember which one, that's in the draft in front of us? I heard administrative difficulty may be an issue, but I'm wondering in terms of in this period of all this confusion of COVID, whether there have been potentially even more overpayments or penalties that have been imposed, that why we wouldn't, if it wasn't the claimant's fault, why we wouldn't try and relieve them of those benefits as well, of those overpayment or penalties as well.
So in other words, allow a retroactive waiver for folks who have already sort of served their penalty for overpayments, allow them to be able to sort of retroactively. I mean, is that what you're?
I guess I'm thinking more, and maybe I have this wrong in terms of the overpayments or penalty weeks where they've suffered a financial harm.
Mm-hmm.
It happened before the enactment of this bill, but they were not at fault, and they get a determination that they were not at fault for those penalties. And now we're saying, well, you served it or you've repaid it, so it's done. We're not going to look back.
I actually hadn't even considered. So this proposal then would allow someone to request a redetermination, but then still have no redress for any penalty that they served as a result of that determination. Is that?
That's my understanding. They could be serving presently ongoing penalty, and that could be waived, but the penalties or repayments that took place prior to the date of the enactment, they would have to just live with, even though they weren't at fault. Maybe I have it wrong, and Damien can correct what is being proposed here, but it seems like there's a cutoff date here of enactment, and it's maybe as simple, do we want to make this remedial step fully retroactive or just prospective?
I of course, if there was any way to address the retroactive errors that were made, I mean, we certainly saw many people who had to serve lengthy terms of penalty weeks, lost out on significant benefits to which they would have been entitled. And it really appeared to us that the underlying claim the underlying claim should have been appealed and likely would have been a favorable appeal. If those folks who suffered tremendously during the pandemic had some ability to retroactively have a claim to those benefits, of course, we would definitely support that. I guess I hadn't considered the idea that a person could could have the determination reversed and yet not have and so that would apply. I thought I saw something in here that did allow looking back, but maybe not. And so I didn't understand that final part to have that possible result. And I think it should be, the commissioner should be allowed really the discretion at least to decide about restoration of retroactive benefits or penalty weeks. I guess you threw me for a loop there, Senator. I guess I would have to think about, I mean, of course, legal aid would support any measure that would improve benefits for claimants and restore lost benefits to claimants as far back as we possibly could go. So if there was a way to do that and allow claimants to be reimbursed for effectively underpayments of benefit, we would support that.
Thank you.
Thank you. Anyone else? Okay. Thanks. If you can hang on while we move through to the next section, really appreciate it.
Thank you.
Commissioner, director, who will join us. What?
Do you mind if we come on
No,
together?
of course not. You're, all three of you are welcome. Emma, if you want to join them as well. I join. Y'all are also welcome to rearrange those chairs back there. If that's
They're very close together.
They're very close together.
So pre-pandemic.
And most everything in this building is, in fact. I think we have both mechanical questions for you and policy questions for you. And the best we could do to differentiate those things, I think the easiest this conversation is for everyone. Would you have one that you would prefer to start with?
No, I'll just say for the record, Michael Harrington, Commissioner, Vermont Department of Labor. I'm joined, I'll let Cameron introduce himself, but with our Director of Unemployment Insurance. And happy to provide comment or answer any questions the committee may have, whether it's with regards to the legislation that's proposed or anything else. The only comment I will say is it's hard to discuss individual cases, as Ms. Kuzmarski brought up. We do focus and have provisions for due process, and whether or not an individual takes up those opportunities is outside of our ability. So if someone, if the department tries to contact a claimant, but the claimant does not respond, or the claimant does not choose to appeal a determination, that can play into the matter. And I can't speak obviously to the specific instances. Certainly from my standpoint, if someone is deserving of benefits, we will do everything in our ability and our power to ensure that they receive those benefits. And whether we agree or disagree on existing law, I'm sure we could go through our own state law and federal law and find many places where we disagree with what's written, but we are also charged with administering the program in accordance with the law. So, there may be great opportunity in the legislation that comes forward that would allow us either more flexibility or more aligned with our values as a state and as a department. So thank you.
For the record, Cameron Wood, Unemployment Insurance Division Director for the Department of Labor. I have thoughts in my head that I would like to share. I'm happy to kind of walk through the general process of how we determine fraud claims, if that would potentially help.
Oh, I don't think we need to do that. No, thank you.
I
I feel like I've heard you do that before.
Sure.
Imagine most people.
I would like to make kind of the opening remark that, as a general matter, I understand that individuals were in a very difficult position during a global pandemic where they were being asked to stay home. We're not necessarily in a position to go out and find a new job based on a layoff. So I try to compartmentalize this, at least for myself, of recognizing there may need to be things that we do to address situations like that, as opposed to just our normal course of business. Because I want to remind everyone that we're talking about penalty weeks. And when we talk about penalty weeks, it's because the department has made a determination that an individual has defrauded the state of Vermont and received benefits that they were not entitled to. And sometimes I think that gets a little lost when we're just talking about people who have an overpayment. But we don't just, I would respectfully disagree with Ms. Guzmarski, we do not just issue determinations and send them out applying fraud to people. That is not how our process works. As the commissioner mentioned, we do have due process requirements. We do provide those. We provide the determinations in writing. Individuals have a right to appeal that determination. If they appeal that determination outside of 30 days, they have the right to express to the administrative law judge the reason they did not file that appeal timely. And if it is for good cause, in my experience, the administrative law judges or the Employment Security Board will generally require it to be remanded to us to take additional fact finding. So I try to remind everyone regarding this conversation that this is what we are talking about, individuals who have defrauded the state for benefits that they were not eligible for.
And just to put a fine point on that, intentionally defraud the
Yes.
state. So we do have cases where someone accidentally misrepresents a material fact or unintentionally does, and those individuals, we do not assess penalty weeks to those individuals, or we will waive the penalty in those cases. So these are individuals we're talking about who, in some cases once, or in some cases multiple times over multiple years, defrauded the system. Typically, what happens is they go back to work and earn wages, but they know that earning wages will offset their benefit amount, and so they choose not to report those wages. So they're actually double dipping, receiving wages and benefits at the same time.
So, and I'm looking, as I said at the beginning, I'm looking forward, and I think we're all looking forward to the auditor's report that really is going to put some fine definitions on a conversation that I think everyone's been having longer than I have. And so I think that will be very helpful to really put a fine point on this legislation. I would love to hear from you specifically about the mechanical ability to waive penalty weeks in the future, but retroactively. So not sort of as this legislation reads. And then I'm also curious if a 50% payment would be at all possible for you right now.
Quickly, I'll try to walk through this, each section, if you will. The first section, without having spoken with the commissioner about it, I don't see a problem with necessarily. We're obligated to follow this as it is right now in relation to the federal programs. As Damian mentioned, we have federal guidance that we are obligated to follow in relation to that program, and I think this articulates it well. We're currently struggling with the same things that the committee has identified with how do you define the word unconscionable, et cetera. We're working through that now, but we will have to move forward absent this language regardless. But this in its draft form, I wouldn't necessarily have a problem with because it really mirrors what the federal language is. Moving forward, the second piece here on page 3, when it specifically requires us to waive any overpayment for which an individual is without fault, I would ask that more be added there. I think Senator Sorokin brought up a fact pattern, and there are many others that are similar where somebody may not be at fault for something, but that should not, from our perspective, relieve them of the obligation to repay money back to us. Could be claimant's fault, could be employer's fault.
But mechanically, you're capable of doing that.
Mechanically, we are capable of waiving if the individual is not at fault, correct?
Okay, thank you.
The system does not waive anything. It requires manual intervention now. So
Thank you.
our staff have to make a determination of whether to waive something before it's actually waived. Moving forward, mechanically and policy. Our general counsel is not in the office, so obviously we haven't had a chance to speak with him about the clear and convincing evidence standard here. So if it's okay, I'd prefer to hold my position on that for now until having had the opportunity to speak with him. The no more than 50%, I can't answer right now whether that is something that our system could do. I believe it can, because we do set up repayment plans with individuals. So I think it is possible, but those are two different things, repayment plan versus what the system will allow us to recoup on a weekly benefit payment. So I'm not sure off the top of my head whether our system is capable of requiring every instance where there's a payment and an overpayment that we only collect 50% of that. Or we only withhold 50% of that.
Approximately how many people do you have in that category in this month?
In
And
overpayment.
overpayment,
Mhm.
do not know the answer off the top of my head.
Like, do you know if we're on the scale of thousands or hundreds? That's all.
Oh, I have no doubt it's thousands.
Okay.
My question is whether it's tens of thousands.
Okay, great. Thank you.
So mechanically, no.
Yeah.
So you just said, I have no doubt it's thousands. But there's what, 4,000 people in a given week?
Right now, I
So
believe
just help me, maybe I'm not understanding. These are people that had too much benefit paid, and now the facts have sort of getting clarified, and so we're recouping that while we're still giving them some benefit. Is that the scenario?
No benefit.
so. Right now, we have, I think it's, we're down to less than 3,000 individuals, I think, on weekly claim, filing weekly claims. When we put someone in overpayment, they're not able to collect UI benefits until that overpayment is repaid.
I see.
And that could be for somebody who isn't a fraud determination, but they have been overpaid, and we've deemed, that it's reasonable for them to pay it back. In instances, people are overpaid and we waited because the claimant is not at fault, and we've determined that they shouldn't be required to repay that benefit amount. And then we have the individuals who we've determined have been overpaid, and because of their failure to provide information, their misrepresentation, we determine it to be fraud. And those are the individuals who have an overpayment plus the addition of penalty weeks onto their claim.
So they just kind of hang out there until such time as they were to try to
Yeah, so the
I see.
conundrum with penalties and penalty weeks, right, is that unless the claimant writes a check back to the department, their benefits are deducted each week that they're filing to pay back the overpayment. Same every time they file a weekly claim and they have a penalty week on the books, the penalty week is served. But if they're not filing anymore, and so when Cameron talks about thousands, that doesn't mean there are thousands of people filing right now, and we're deducting their benefit. These are people who may have been determined to have either frauded or need to repay the department, but are no longer filing.
Okay, thank you.
And then the ratio of people who are in overpayment because of fraud versus people who are in overpayment because of.
And I don't know, we could find
Okay.
that number. It's not something our system currently tracks. I will say that, to Cameron's point about the 50% offset, again, we can certainly go back to it's not something we do right now. So regardless, it will be something that we would have to figure out how to make our mainframe do. Now, it may be something that, you know, is less heavy on the technical side because we have payment plans and other things, but it would require some change or alteration to the mainframe. And so again, I would just circle back to, you know, our position right now is that nothing be implemented that makes changes to the mainframe for safety reasons.
Thanks.
The only piece I would add too is, and this is more of a general statement when we talk about retroactive or going back in time, that's like the death knell for the Department of Labor because so many things change over time. And so having an automated way to go back, to redetermine someone and then figure out how to either pay their benefits or offset their benefits in the past, but now currently, you know, that is something that you know, is extremely challenging, heavily on the manual side, if not all manual, but it takes into a wide variety of other considerations like what is the impact to the employer at the time? Do we actually still have the claimant's current information in our system? Right, if it's 3 years in the past, we're likely to not have current contact information for that claimant if they're no longer filing. If it was, you know, a couple months in the past, that may be different.
So
I think
I can't imagine any scenario where you would have modified or overturned an original termination without being in touch with the person presently, because they would be engaged in some conversation with you about it.
yeah, unless there was something in the legislation that said we could only offset penalty weeks or offset benefit offsets by 50%, and then we needed to go back in time and repay 50% of people's benefits.
I was on a different page than you are.
So I was thinking more globally. I was just talking about retroactive in general. It just makes it extremely hard and in many cases not feasible.
I would 100% agree with the commissioner there. And with our conversations with USDOL, they've raised any retroactive provisions that we try to do as a potential red flag.
Can I just come back to this universe of people who are in penalty? When you track down the sort of crude data, just to give us a scale, that would help me out. Could you also help us understand, you know, if somebody owes you $10 and they're on the list, that's, you know, something I'm fast forwarding when we come in and hear how hard this is and how big the numbers are. And it's going to be important to me to have some kind of categorization so that, you know, if it's 2,500 people, but 2,000 of them owe you $40 and 500 owe a significant amount. I'd like to understand not just the raw number, but some categorization if that's possible.
And the auditor's report sorry to be a broken record about this, but my understanding is it's going to have these really helpful sort of discrete categories and a range of sort of a spectrum of what fraudishness, which I'm sure is not what they call it in the report, but is essentially how it plays out.
One thing I can tell you is, you know, for example, circling back to my opening comments, you know, we received information from USDOL recently looking back at a 12-month period. This is just a snapshot of the information, but, you know, we issued, I think it was over $8 million in overpayments over the past 12 months. 65% of those were because claimants failed to provide us with information. It is strictly a claimant's failure to provide information to determine their eligibility that led to that overpayment. And that's where I'm, again, trying to make sure we're having a frank and real conversation about what we're talking about when we're talking about penalty weeks. Separate from that, moving forward, the automatic waiver of penalty weeks, either in the event of a state of emergency or upon passage of 2 years from the date of determination. You know, I don't, again, know whether that is something that can be done mechanically. I don't think so. I know that our Deputy Secretary of ADS has testified in the past that there was provisions in our mainframe in the past that did automatically waive penalty weeks. I think we've expressed and he has expressed the concerns with how that's actually done when you're talking about going in the mainframe and entering individual socials to make that happen. So
The only clarifying point, because I did ask this of our ADS team, to go in, so there isn't an automatic way, right? So everything with regards to penalty weeks is manual. So you would, in the case of a global pandemic where there's 100,000 people coming through the door in a matter of 90 days, to actually go in and waive what was likely thousands of individuals that had overpayments or penalties in the system would have been a manual one-to-one process. What I will say is that waiving overpayments, so disregarding them completely, essentially throwing them away, never to be served again, is potentially feasible. Suspending them right now is currently not. So you can't suspend, based on my conversation with ADS, without maybe further determination of looking at the system. But we don't, if someone was serving, had 5 penalty weeks on the books, we could suspend those penalty weeks for a period and then reinstate those after the fact.
Is there suspension language in here that I?
No, I just,
That's
when
okay.
we say, waive penalty weeks, I just never know whether we're talking about waive indefinitely or waive temporarily during a state of emergency, right? So what happens when the state of emergency ends? Are those penalty weeks reinstated for situations of known fraud, or are we simply?
Damien, the language here is waiving permanently. Yeah?
Yes, it is waiving permanently. There were proposals during the past legislative session that would have had a temporary waiver. And I just wanted to note one point on the language that was, I believe ADS called it suppressed in the system for the 3-year waiver. That dates back to a change in the statute shortly after the last major recession, when we were adding the 15% penalty that US DOL required. We took out the automatic waiver after 3 years in the same bill. So I can't remember if that was 2011, before my time, certainly. But it was part of that bill to update us to the federal requirements on collecting a 15% penalty for fraud, that we took out the automatic waiver.
Thank you. Did you say you wanted to come back to us on the clear and convincing language?
I would like to, without having talked to our general counsel about it.
Okay. Can I just, for my own understanding, Damien, and perhaps for the witnesses, are we saying here that if there is fraud that we can establish by clear and convincing evidence, those are not, they do not reset after this 2-year phase, right? Is that the construct here?
So the way the language is set up, first, the department would have to make a determination of fraud by clear and convincing evidence. They could then impose penalty weeks and the penalties as per their current practice. But at the end of 2 years, the penalty weeks would go away. They would be waived at the end of 2 years, whatever hasn't been served. The penalty and overpayment is not proposed to be waived in this, because that's required under federal law. So that 15% penalty, we have to impose that, we have to collect it. That's not something we can waive, but the penalty weeks are something that we could waive, and some states do that. But states there's 50 states and 4 territories or something like that with UI systems. And there's more than 50 different ways of addressing this. Every jurisdiction has a slightly different approach, whether it's criminal prosecution or penalty weeks. Some states assess 100% penalty on fraudulent payments versus the 15% we do. So there's wide variety. We have some discretion with anything above what the feds require, but we have to do that penalty.
But the construct here is penalty weeks evaporate after 2 years, no matter how you got there.
Yes.
And on the policy piece of this is where I would be somewhat opposed to that, as you know, the commissioner highlighted the challenge, you know, I don't think it's a challenge for us. The reality for penalties, the unemployment insurance system, is we do not get to impose them unless the person is interacting with our system. So for many people who have penalty weeks, we've had many of them eligible to file an UI in the past, and they choose not to file because we tell them you have X number of penalty weeks, and they say, well, I'm not going to get benefits, therefore I'm not going to file. Our position is your penalty weeks will remain until you actually serve them. It's in your best interest to file and serve them. And so we actually don't have the ability to proactively, if you will, it's not the right word I want to use, actively impose a penalty. It really depends on the claimant interacting with us.
I think you bring up a good point, Senator, in that fraud comes in many different shapes and sizes, and probably levels of severity too. And so, you know, we're also talking about legislation that in some cases would treat them all the same. And that may be something the committee wants to consider, because we do have instances where, for instance, an individual, this is a real circumstance, created multiple businesses over multiple years for the sole purpose of laying himself off to collect business benefits to the tune of close to $100,000
So much effort.
in UI benefits. What's that?
That's so much effort.
Get $100,000.
It actually is not a lot of effort, but in this case, you know, this person over probably, you know, more than 5 years, probably closer to 10, defrauded the system each and every year by creating a new business, laying himself off and collecting benefits. And so you'd essentially be saying in that case, after 2 years, the slate is wiped clean and he's good to go. So again, there are many different layers and levels of types of fraud, which is much different than the folks that probably end up before legal aid, where they either feel like they misunderstood the system or, you know, decided that it was in their best interest to not only work but collect benefits as well. And I certainly understand that, you know, during what is probably the worst time in someone's life, you have to make decisions for your own personal health and safety and for that of your family. So I just wouldn't put those people in the same category. And we may want to have thoughts about that.
Would it be possible to create a hybrid that people have to pay back 15%? But would it be possible to give them the choice after that to either serve penalty weeks or to pay a further penalty? So that if they chose to pay the further penalty, it gets wiped out right away and they're done with it.
I don't have an answer yet, so go ahead.
These have been conversations we've been having with Resultant, the entity that was hired by the auditor's office to do this fraud review with the department. You know, at the end of the day, penalty week is a monetary penalty in the sense that the claimant is not being given benefits and that money is being deducted from their maximum benefit amount. So it is a monetary penalty. It's one that we don't collect. And so we have had conversations with, you know, Resultant about this and about whether it makes more sense to have a tiered structure dependent on what severity of fraud, whether it makes sense to have a monetary penalty as opposed to a penalty week. In that instance, somebody could pay it back and then they would be eligible for unemployment moving forward. I would not be opposed to a hybrid if it was asking them which they would prefer. It would not relieve us entirely of this conversation, because if we were in the middle of a pandemic again or recession and somebody served penalty weeks, we would be sitting here saying they chose that, and people would be asking us to waive them anyway because of the circumstance.
The other piece that I'm hoping Resultant comes back to us with too is this idea of what are appropriate options for deterring fraud. I mean, part of the penalty structure is designed to discourage somebody from committing fraud. So as we make penalties either less or less punitive or exist for fewer amount of time, it does open that door for someone to feel like that may be an appropriate risk to take, because we do not have the statutory authority to seek criminal charges for unemployment insurance fraud. And that may be something we want to consider as well, putting back into legislative language. It used to be there, it was removed. So in all honesty, the repaying of the benefit, the 15% federal mandated penalty and the serving of penalty weeks are typically our three go-to for fraud deterring and fraud prevention. And that, I think, is something that this committee should consider.
I think there's a lot of questions globally in the world, in this unemployment system and, in the criminal justice system about whether or not punishments deter, people are even aware of punishments when they're making decisions, and that deterrence is actually about the communication that happens at the time that the person is making the decision or before they make the decision. I think very few people have any idea that penalty weeks exist until they have them. And so unless they're sort of gossiping to their neighbors about what happens, then I'm not sure how helpful it is as a specific deterrent as much as a punishment. I also feel very aware of the time, and I'm trying to make some decisions about that. So
Very quickly, I just wanted to highlight, I think that is something we've talked with Resultant about. I've talked with them extensively. I'm hoping that with a new modern claimant portal, there's a lot of work being done with behavioral insights tools, et cetera, to try to nudge people to making the right decision as they're filing a claim. And so that's something we're very aware of. I sat on a webinar just yesterday about that. And so something we're definitely interested in.
this very last new section.
The last section here about reconsideration of a determination.
If the commissioner modifies or overturns the original determination.
I've spoken with the commissioner about this. I don't have a strong objection to it necessarily, except for the fact that I have very limited resource availability to my team.
Yeah.
And anytime we're doing something like this, it takes away from our ability to potentially provide benefits to somebody, for example. And I just want to be very clear that just by adding this, we're not going to be taking every case that somebody comes in and says, I didn't participate in the first appeal, now I want you to reconsider it 2 years later. We will not be hearing those. It will need to be a showing of good cause as to why someone did not participate. And I will be very clear that if you're going to require us to make a finding, based on clear and convincing evidence, it becomes much more challenging to make a determination either way, the farther out you get from the facts of the case. So when somebody comes in 2 years later and says, I want a redetermination, and we're looking at the facts we had at the time we made the determination, and somebody's simply telling us, I didn't participate, well, why didn't you report your earnings at the time? I was in a bad place, I don't remember. We're not going to use that to say, okay, now you're eligible for benefits. And I can't stress enough, those are the fact patterns that we get. We have information that shows that you earn money. We ask you why you did not report them to us, and the person will say, well, I don't know, I didn't know I had to. Something to that effect. And for us, the clear and convincing evidence is you earned money, you didn't report it. That's fraud.
I would be very curious to hear what staff capacity you would need to meet Vermonters' needs in this particular way. I know that's a complicated question to ask you, but I think it's something that needs to be on the table as we talk through this, and to understand better if that's something that would be covered by federal funds or not covered by, like if that's outside of the purview.
Can answer your second question.
Yes,
It would be covered by federal funds, but we don't have enough federal dollars to cover a program as it is now.
great. I mean, that's not great, that's terrible, but I appreciate the clear answer.
Well,
Yeah.
then I wonder if this 2-year time period is too long as well.
Too long.
Yeah. I mean, I'm wondering if 1-year time period. I mean, I agree with Cameron. After 2 years, if a claimant hasn't written anything down, they have no clue why.
Yep.
Why they had put the claim in and why it was rejected and why they were found with fraud.
Absolutely, and I understand that what you see as a fraud pattern, I think someone's lived experience is just the chaos of paperwork in someone's life when they're in crisis, and that finding a way to the middle often requires more staff than you all have right now. So I'm going to switch gears.
Would you like us to step down?
I think so, if you don't mind.
Yeah.
And we are going to talk about the reimbursable employee changes, which we reviewed completely at our last meeting a whole month ago. And I'm not going to ask Damien to review right now because we don't have as many minutes as we were going to. No one on the committee suggested anything in the interim regarding that language. There was some curiosity though about hearing from other witnesses about it. And so the two pieces were that everyone, this is my quick summary, forgive me, Damien. Everyone is, all nonprofit employees would be covered by UI. No size of employer would be exempt from that. Senator Strachan, I believe you had a question in the interim, but that employer, that nonprofit employer could then choose to be reimbursable or not, exactly the same way any other nonprofit employer could choose to be doing that. And so, and then the other piece is this reversing of liability around in circles, which I'm sure people have more questions about and Damien can answer them. But first, I would actually love to hear from Jesse Bridges from the United Way, who's going to share with us the perspectives of the nonprofit sector on these things. After much hunting and the very helpful work of Common Good Vermont, we have finally found someone from a nonprofit to talk about this with us. Thank you so much. If you could identify yourself for the record, I appreciate it. Welcome.
Thank you. Can you hear me okay?
We can, yeah.
Okay, great. So my name is Jesse Bridges. I'm the CEO of the United Way of Northwest Vermont. We provide some written testimony, which I'll go over today. But as you'll see, we have recently merged with Common Good Vermont, the Council of Nonprofits for the state. So I'm here to speak on behalf of both United Way of Northwest Vermont as a nonprofit employer and Common Good as a nonprofit convener. So United Way of Northwest Vermont employs between 23 to 30 employees. We're trying to hire in this environment right now. And that includes Common Good staff. But we're connected to thousands of other employees and organizations through our unique position at the intersection of nonprofit, business, government, and community. Our experience this past year illustrates some of the unique challenges and disadvantages for employers of our size in the current structure. We were significantly impacted by 2 claims in 2020 that had impact on our annual budget in a time of significant financial strain. We had one employee resign prior to the pandemic in March 2020 for another job on their own. They had a new opportunity. Unbeknownst to us, until we received a bill from the state for their UI claim, that employee was no longer employed in the job they had left our organization for, but we were responsible for that UI reimbursement. An additional employee with a predetermined contract period that ran through March 30th of 2020 filed for unemployment benefits during the pandemic shutdown, but their job was not unexpectedly terminated by us, but we were still on the hook to pay for their claim during the pandemic. Despite not being responsible for either individual's unemployment and both charges being related to COVID-19, we were still on the hook to reimburse for their UI charges. All benefit charges were automatically relieved for taxable employers in 2020, and charges related to COVID-19 were covered in 2021. Even with CARES and ARPA relief, reimbursable employers still had to cover partial costs, 50% under CARES, 75% under ARPA through September of 2021. This is an additional burden on nonprofit organizations who have been providing essential services throughout the pandemic while dealing with the same workforce issues of taxable employers. Furthermore, while taxable employers can dispute claims they were not responsible for, reimbursable employers cannot. This practice, even under normal economic circumstances, forces nonprofits operating on lean budgets with significant unanticipated expenses come at the cost of current staff and the essential services and programming they provide. We can only speak to our experience, of course, but with a longer runway, we can work to convene other organizations to paint a fuller picture. We really appreciate the committee's attention to this issue and look forward to supporting its work towards a solution that mitigates the unwarranted financial burden on reimbursable employers. Next, I'd like to share some context on the sector from Common Good Vermont. Common Good serves and advocates for over 4,463 501c3 public charities. 86% of Vermont nonprofits report less than $500,000 in revenue. While larger organizations receive the majority of their revenue from program services and larger funding streams, smaller organizations rely on charitable contributions, gifts, and grants as their primary sources of revenue. These operate with modest revenues and many with less than 6 months reserves and employ a very small number of staff. These nonprofits often provide essential services to Vermont communities and the state of Vermont. In fact, 20% of our sector work in health and human services, 16% arts and culture, 16% community and economic development, and 14% education. I'd like to speak to the proposed eliminating the UI exemption for nonprofits with fewer than 4 employees on behalf of Common Good Vermont. I understand the Common Good team is asked to support the committee with identifying impacted nonprofits and providing data that would illustrate the scope of the issue. Common Good is committed to working with the committee, a convener role going forward this session, and is asking the committee for a longer timeline to properly assess the impact of UI changes through convening and data work. Many nonprofits, particularly small organizations impacted by this proposed legislation, are limited in capacity and advocacy experience. They require information and training to understand the issue and how to advocate on behalf of their work. To this end, in addition to direct outreach to nonprofits, Common Good Vermont is holding a pre-legislative session event in December to provide advocacy training and convene organizations around key issues such as this. Additionally, without a clear picture of the scope of the impact, nonprofit serving groups cannot adequately advocate on their behalf. As Common Good has testified before, we seek increased, transparent, and accessible nonprofit data from the Department of Labor and other agencies. Data helps assess the short-term and long-term needs of the sector. Without it, we cannot quickly assess facts to provide policymakers like yourselves information to guide your decision-making. For example, when federal guidelines changed the self-insured unemployment reimbursement rate from 50% to 100%, it was and still is unclear how many nonprofits were impacted. The Department of Labor, being under immense pressure from unemployment applications, had little resources and time at that time to provide data to assess the state impact. Common Good Vermont's Economic Impact Report and nonprofit database pulls data directly from state and federal databases. Without accessible employment data for nonprofits, we cannot speak to the scope of the impact this legislation would have. Additional information sources, such as raw 990 data, includes the number of employees for organizations with gross receipts over $50,000. However, data work for this level requires operational and financial investment in the short term. Common Good would recommend the state implement tracking measures to account for this critical information gap for nonprofits in the long term. United Way of Northwest Vermont and the United Way Network, as well as Common Good, appreciate and concur with the aim of this proposal to support nonprofit employees. We know they are the heart and souls of our nonprofits, the ones on the ground doing the work, and are deserving of equal protections. That said, in consideration of the limited available data, and because the elimination of the small nonprofit UI exemption would have budgetary implications for the most vulnerable organizations, we ask that any changes being made include a longer timeline. This time will be critical for small nonprofits, particularly those who rely on state and federal grants, to take necessary action while minimizing operational and programmatic cuts. We will continue working with the nonprofit community to better understand their experience as small and self-insured employers, and we'll encourage them to share their stories with you. Please reach out to Common Good Vermont or myself. We can be of further assistance now and as we enter the legislative session. Thank you for your time and consideration on these matters, and I'm certainly happy to try and answer any questions that you might have at this time.
Thank you. My question is, I've been trying to better understand the business decision of a largish nonprofit like yours to choose to be a reimbursable employer. It's always struck me as incredibly stressful from a financial perspective to not be able to, that it would make it harder to plan. Can add sort of on the flip side of those impacts from the pandemic, are you thinking about changing your status, or is that something that you all have had conversations about and we've talked to your colleagues about?
First, it is an interesting position to be in, to be considered a larger nonprofit with a just over $4 million budget and less than 30 employees. But in the context of our state, that is fairly true, right? And so it is something that we will consider. I think our organization hadn't really seen the impacts of UI claims previously. And so I think, those tend to be unexpected expenses. Nonprofits in general, because we operate on, little to no margin, are often looking at all kinds of ways that we can reduce annual operating expenses. And so, not having that annual expense per employee is probably one way in which employers of our size are mitigating their costs. But the unexpected, consequences of things like what happened during the pandemic are certainly something that we will have to take into consideration, and probably will do, yes, in concert with many other nonprofits of similar or smaller size.
Jesse, thank you for coming in. Appreciate the testimony. I guess what I would say during the pandemic, where taxable employers were relieved, they were relieved from their experience rating, but they're not relieved from paying in their taxes. And so those employees are still receiving their unemployment, but it's being socialized by all of the taxable employers. So they are paying. They're just paying over a longer period of time. So they're actually not relieved. It's just that one employer is relieved from their experience rating. But on the reimbursable side, nonprofits don't pay in anything until an employee is on unemployment. So I think we need to understand that, yes, the taxable employer was relieved, but the system itself that all the taxable employers pay into covered that cost. And so, yeah, as a taxable employer, I've been in business for 38 years and I've had one employee collect unemployment in those 38 years. So I've been paying in. So what I've been paying in helped to pay for that employee, that piece of it. So I want to be clear there that it's a choice that reimbursables make, and I understand that. On the small nonprofits, I want to understand more of the effect on the nonprofit, but at the same time, I don't want to go too far down the road because we have employees that are not covered. And from my understanding, from what we heard in testimony, the employee didn't even know that they weren't covered until they lost their job during the pandemic. And what happened to them was they had no recourse. They couldn't find a job and they couldn't get unemployment. So I think that, as you said, we want to make sure that the nonprofits can survive, but we also want to make sure that nonprofits employees are taken care of during the time where they lose their job through no fault of their own.
I would agree with that 100%. And part of what we are here to do, and I think reflected in parts of my testimony too, is to support the employees. It's not just about supporting the organization and the mission. Part of the mission has to be to support the people who do the work as well as the work itself. And too often in the nonprofit sector, particularly in small nonprofits, that is not, it's mission, not, and the mission is not always aligned with supporting people in the same way. And so we're supportive of changes that will make sure that nonprofit employees are well supported. And I think part of that is making sure that their organizations that they are working for are viable.
Thank you.
Thank you. Senator Strachan?
Thank you for your testimony, and I thank Representative Marcotte for stating eloquently the concerns here. Is there any sweet spot you're aware of as to a size of a nonprofit organization where you feel that they shouldn't have the option of being a reimbursable employer?
I wouldn't be able to answer that question without further data and information and study on that question, but it's an interesting one of whether or not there is a particular size of nonprofit that should be kind of mandated to go into one bucket or the other. There are a lot of different types of nonprofits, of course. Not all 501c3s are the same, and so just like no businesses are the same. So I think thinking about that in the context of nonprofits, just like we think about with business, small and large and mid, would be a valuable thing. And as I commented on for the work that Common Good has tried to do in collecting data in partnership with the Department of Labor and others, there's oftentimes limited information that we have to make those determinations.
Do you have any information among your membership as to which route most of them choose?
Again, that's where there's limited data. Common Good and our organization are preparing to do, we are doing some assessments now based on organizations' previous participation in this. Many small nonprofits don't even have their finance staff in-house, right? So a lot of them are outsourcing to bookkeeping and other organizations. So the knowledge within the organization is often limited. And so the reporting has to be done in an aggregated way. And so we're committed to trying to find the capacity to pull that type of work together and understanding that, particularly in the last 2 years, the state's been under immense strain. And so we really haven't had capacity to expand data gathering options. Neither have we. And so that's definitely an area of focus as we move forward.
Thank you.
I have high hopes that the Secretary of State's new database is going to also help with this nonprofit data problem so that we don't have to look at individually scanned records in order to figure this stuff out. Damien, what are our federal rules regarding offering reimbursable employer status?
We are required under 26 USC 3309 to provide nonprofit organizations with the option to become reimbursable.
Regardless of size?
No, above 4 or more employees. So we're not required to cover fewer than 4 employees, but some states have elected to do that. So, but yeah, we are required to allow them to be reimbursing employees and to cover them when they have at least 4 employees.
Thank you. And my understanding, Mr. Bridges, is that you all are convening a group of nonprofits to discuss this further so we can get some better feedback from you all.
Correct. Yeah, we're working to pull together in the coming weeks, actually, nonprofits to come together on this issue in particular, and we'll be looking to generate feedback across the multitude of types of nonprofits as well as throughout the state.
Ms. Paradis, I'll call on you in just a second. Thank you. So I just want to name, as Representative Marcotte said, that we need to protect our employees as well. These are really basic labor protections, and given the scale of the nonprofit sector in Vermont and the percentage of employees that we're talking about working in the nonprofit sector, and given the labor challenges in the nonprofit sector right now, I think doing everything we can to protect those employees will serve all of us very well. Representative Marcotte, you have something?
Yeah, thank you. Jesse, when you have when all your nonprofits have a meeting, could you ask the small nonprofits with 4 or less employees if they have disclosed to their employees that they're not eligible for unemployment? I think that would be helpful to us to understand, that dynamic, what's going on with the employer-employee relationship.
Absolutely. That would definitely be something that we would look into. And like many small businesses, for employees, there's no HR, right? Or one person's wearing 6 hats. And so that's definitely a topic that we would want to help them understand, not just whether they're making employees aware of that, but are they aware of it themselves? And so I think that's the good outreach and advocacy that we can do. And the representative's point about the sector, we appreciate the acknowledgement of the scale and scope of the nonprofit sector, part of the Vermont economy. 1 in 7 Vermonters are employed by a nonprofit, so it's a big piece.
Thank you.
Thanks. Ms. Paradis, did you want to add something to testimony?
For the record, I'm a Paradise Program Associate, Common Good Vermont, and I was just put in the chat there some data from our recent wage and benefit report that Common Good Vermont does every year, and the data that's only has 106 nonprofits reporting for Vermont says that 17.9% of those are exempt from UI coverage and 15.1% were self-insured, just for context in a very limited sample.
Thank you. Can you send via email that data so we can post it? The chat is not part of the public record because of
Absolutely.
you all kinds of things. Thank you. Appreciate it. Senator Strachan, did you have a question?
I did. Just to follow up on the comment about sizing the nonprofits. So what I heard Damien say is that it would be impermissible to require certain large nonprofits to buy into the system or be reimbursable. I mean, they would have to be offered that choice, I should say. We couldn't mandate that they be part of the traditional system because that would be in non-conformance with federal law.
Yeah, what the federal law says is that the state law shall provide that a nonprofit organization may elect for such minimum period and at such time as provided by state law to pay in lieu of contributions an amount equal to the amount of compensation attributable to the service that the individual performed for that organization. So I'm paraphrasing because of the incredibly roundabout way the federal law gets to this point, but it basically says we have to provide nonprofits with the ability to elect to be reimbursable employers. So you'll see, if you look back at the handout I provided to the committee at the very first week, every single state provides for reimbursing employers. Some states do like Vermont, and they allow employers to request to pay a percentage of their payroll and then true up at the end of the year based on varying costs. Some states require some sort of bonding requirement, which depending on the state can actually have the function of driving more nonprofits towards becoming contributing employers rather than reimbursable employers. And at least one state has that bonding essentially done with the Department of Labor, where the employers put together a fund that the department draws down to pay their reimbursements. And then based on experience and expected future experience, they bill the nonprofit to refill that fund. So the trust fund always gets paid, but then the nonprofit has to refill their account with the department that is functions as a bond, essentially to guarantee that the benefits get reimbursed. Generally, they're billed on a quarterly basis from state to state, but there is some variation on that. But this is in a handout entitled Summary of State Laws Relating to Reimbursable Employers, and it gives a 50-state summary. that the committee can look over, and I'm happy to send a link to the document to Mr. Bridges and Ms. Paradis too, if that'll help when you're talking to your members. Because some members may also have other branches in other states that they can reach out to and find out if things might work better, for example, in Connecticut than they do up here for them, and we can look at whether that's something that's doable in Vermont.
Damian, that was something that was on our page from our first meeting.
It is. It's on the website under September 14th, or if you go under witnesses, it's under my name for witnesses. So it's something you could access right now. Yep.
Anyone else? Okay. Thank you very much for spending this time with us, and we look forward to continuing the conversation.
Thank you for having me, and thank you for your work on this.
Thank you.
Would you like to come back up to this little table?
Sure, do you have any questions for us? I'm not sure we guys really.
I think it's just like, do you have an opinion? I think that's the question.
I don't think we do it.
Okay, great. Then stay in your chair. Thank you very much. Okay, completely switching gears now.
Can I just comment to you that,
Please do.
you know, I'm not steeped in these details, and that feels like a pretty big change to me
Yeah.
that I don't understand at this point. We haven't heard clear, you know, the constituencies are still gathering stuff, so. For you all that have a lot more experience on this matter than I do, but I'm not eager to rush into that, let's say.
Agreed. I don't want to, I wouldn't want to recommend anything definitive until after they have their meeting and actually get to talk about it. It's been quite a journey to try to get in touch with nonprofits on this one. So. Okay, we're gonna switch gears. But before we switch gears, we're gonna take a 5-minute break because I really want that. and Maybe you all do. And when we get back from our 5-minute break, we're gonna talk about how to get more money to Vermonters.